We're back after a brief break. You're watching Attorney Joe Flores. I'm also a nurse practitioner, proud to salute my brothers and sisters in healthcare. This month marked the 52nd year that nurse practitioners have been around. For those of you who don't know what nurse practitioners do, we can diagnose, treat, and prescribe in collaboration with a physician here in Texas. And so my hat's off to them, and also to the caregivers who work free, those people that take care of mom and dad without a penny. Thank you all for what you do in caring for people, and those that have seniors and veterans out in their neighborhood. I want to take this opportunity to tell people, go visit a senior, go check on them, go make sure they're all right. It'll do your heart good, and it'll do their heart good. Okay, with me coming back is a good friend of mine, good colleague, Mr. Mark Stolley. Mr. Stolley has been, for over 20 years, has been practicing law. If you're just joining us and on YouTube and on other social media, you'll be hearing him talk about the juvenile justice system, child protective services, and also giving a balanced view now on the adult system. Welcome back, Mark. Thank you.
Thank you for having me.
Yes, sir. During our series of interviews, I think people want to know, it affects a lot of people. We are incarcerating more people than ever for whatever reason, and I think that now people are becoming aware that because of the severe drug laws that have been in place, that a lot of people have gone to prison for a very long time in the federal system. But let's just concentrate. I know that you do have a goal of serving on the bench.
Yes.
And we're going to get to that. But right now, you've worked in the adult system a very long time in the very courthouse where you want to serve. So let's go into the adult system. What happens when a person's arrested? Can you walk us through, and maybe some people out there will even get some tips. This doesn't constitute legal advice, but we're going to be talking about the law. When a person gets arrested and is introduced into the justice system, what happens to that person?
Generally speaking, they're arrested on the street. They're taken to the jail. They are magistrated, which is they go before a judge, and the judge, I believe in 48 hours, will magistrate them and tell them, what they're charged with and what their rights are. A bond is set, and unlike in juvenile cases where you don't have bonds, in an adult case, you have a bond, and that's an amount to pay to assure your appearance back in court. You pay a bondsman, generally 10% of the bond. So you get bonded out, and then you wait. And if it's a felony case, you have to wait for. Basically, that case goes from the arresting officer to a detective, and that detective puts the case together, makes sure he's got the witness statements, the lab reports, any other necessary police officer supplemental reports, puts the case together, takes it to the district attorney's office. The district attorney's office has the duty to prosecute criminal cases in the county, and it goes to an intake attorney. That intake attorney will make sure that everything is there that they need in order to present it to the grand jury. The grand jury is that body of individuals who listens to the state's case to determine if there is probable cause to indict somebody. If more like, to use different language, everyday language, more likely than not that a felony crime was committed.
But a grand jury, and I hate to interrupt, that's for the felony, the heavy case.
Yes, for a misdemeanor, it's a little different. Misdemeanor is brought into the district attorney's office, and in the same process, but it doesn't go to the grand jury. It's the charging instrument is called an information, a complaint and information, but the charging instrument is an information, unlike an indictment on a felony, and that can be sworn off onto by a case agent or an officer who has personal knowledge or reason to believe. And now with a misdemeanor, the charging instrument is called an information. And the case agent will generally they bring in a stack of files to the district attorney's office, and they sign off that they have personal knowledge or have reason to believe that a crime was committed by a particular individual. They sign off on that. There's no grand jury process on a misdemeanor, unlike a felony where there's a buffer between the government and the accused, and that buffer is the grand jury. Now, the grand jury listens to the evidence, and they have their own charging power, and they have to have a quorum of, there's 12 of them, they have to have a quorum of 9 in order to either true bill, that means to return an indictment against somebody, or no bill, and that means not to indict somebody. Now they have to believe, in a felony, they have to have probable cause. They have to believe, more likely than not, that a felony offense was committed. And then they return that true bill of indictment. That is the charge. That gives the person, that identifies the person, that gives the elements of the crime, that allows a person to prepare for a defense. Now when that happens, they are brought into court and arraigned. And arraigned means that they are identified as a person named in the indictment, and they are either they have a right to have the indictment read to them, or they can waive the reading of the indictment. Most people choose to waive the reading of the indictment because they've already gone over it with their attorney, that they know what they're charged with, and then they enter a plea. At that point, 95% of the time, it's not guilty. And then what happens from there is the person either hires an attorney or has an attorney appointed to them if they qualify based on being indigent. That person then, with their attorney, the attorney's job is to collect the evidence. It's called discovery, collect what it is that the state intends on using, and review it, investigate the crime, and go over it with the accused, their client. And then from there, it's towards, the preparation is towards a trial to a jury. And then if there are negotiations happen between the state, the prosecutor's office, and the accused through the attorney, that's called plea bargain negotiations. And statistically, 9 out of 10 cases are pled to some agreement. Very few cases go to trial. But what happens is there's some give and take. There's some offer, counter offer, plea to the charge or some lesser charge that disposes of the case. And if in the event that there can't be a plea bargain agreement occur for whatever reason, either the state doesn't offer, or the accused doesn't accept, or for that matter, the judge isn't party to the plea negotiations, and the judge can do what we call break a deal, bust a deal, for whatever reason, too harsh, too soft, and then if we can't have a plea bargain agreement that disposes of the case, then we get ready for trial. Everyone has the right to a jury trial. It's one of our most valuable and fundamental rights in the United States and the state of Texas. A right to remain silent, a right to face your accusers, it's called a right to confront and cross-examine, a right to ask questions of the people accusing you to see if they're mistaking, lying, not being truthful, or just don't have it right for whatever reason. You have a right to present evidence in your own defense. You have the right to call witnesses. You have the right to subpoena documents, to put pictures into evidence, to put video into evidence that shows that you did not commit the crime. You have the right to have your client or have your attorney zealously defend you against the accusations made against you. So those are some of the things that happen in a criminal trial for an adult.
Let's use an example, domestic violence. This is a really hot button issue right now. There is that problem that exists. You as a former prosecutor and then also as a criminal defense attorney, you've done both sides. A man is accused, or a woman is accused of hurting their partner. At that time, they may be arrested or they may not. They may have fled or left the scene and don't even know that they often come into my office and say, I didn't even know that I had a complaint or an information, or if it's more serious, that I was indicted, until I was at the HEB. 2 Suburbans come out and federal agents arrested me. And I had the other day somebody say, why did federal agents arrest me? I said, because they were available and it was warrant day and they go pick up people and help the locals. So anyway, kind of a dramatic example, but it does happen. And people are arrested. They're first time arrested. They're introduced into the system. Domestic violence is a very complicated issue. Often the partner says, I want to drop the charges. And they'll go in and fill out an affidavit of non-prosecution. But does that necessarily mean that the case goes away?
No. The 2 people that, for lack of a better phrase, own the case, the state of Texas and the accused. The alleged victim is a witness for the state. Now, a lot of times the alleged victim In cases, we'll go into the district attorney's office and sign that non-prosecution affidavit, stating that they don't want the case prosecuted, stating that they don't want to be called as a witness, stating that they will not hold the state or the county or the district attorney's office liable for in the event that the case is dismissed. But they don't control that. They don't control whether or not the case is prosecuted or dismissed. It's advisory, but it's not mandatory. And so what will happen is, in the appropriate case, the prosecutor will look into the case to see, okay, who are we dealing with as an accused? Are there other police reports on file where this has happened? Are we dealing with something that we can prove with even without the alleged victim's testimony? Did a neighbor across the street see what go down? If it happened at a store, did the store clerk see? If it's in a home, was there a child or other family member present who witnessed what alleged to have occurred? And those are different ways that the prosecutor can prove a case despite an alleged victim saying that they don't want a case prosecuted. It's unfortunate that some, generally ladies, but it could be men as well, are caught in what we term as a cycle of violence. And there's an actual cycle, a diagram that shows the cycle. And a lot of times it's just repetitive behavior that we see sometimes end up in very tragic results, aggravated assaults, murders of spouses. And that's just unfortunate. But that doesn't mean that if a person says they want a case dismissed, that it's actually going to get dismissed. The state of Texas, through the prosecutor's office, is going to look into that and see, as I said, what are we dealing with here? Is it an isolated event? Is it something we can prove otherwise without the testimony or without the cooperation of the alleged victim?
Well, now I want to take this time. We're filming here in Corpus Christi, but also San Pat, Aransas County, Clayburgh, Jim Wells, they all watch us, and I want to thank the district attorneys for the job that they do, but also those that take on these tough cases, and that includes those that are appointed. I want to take this, next 30 seconds to say that people that, lawyers who take on appointed cases, many people say, well, they're not as good as somebody that I'm paying top dollar for, that if I could afford an attorney, I'd get better justice. And that simply is not true. Often here in South Texas, you get attorneys that are private that earn several $1,000s for a case at a time, but also take on cases for people that can't afford attorneys. So for some, I want to dispel that myth. And also, to underline what Mr. Stolley said, you're watching Mark Stolley, who's also been a criminal defense attorney as well as a prosecutor, that you are innocent and presumed innocent, and you have the right to remain silent, to confront witnesses, and have a trial. With all that being said, let's continue with our example of domestic violence, because it's a hot button issue. People have died because of it. The cycle continues. What happens to the victim? We've kind of focused in on the person that maybe allegedly committed the assault. Maybe it's not their first time. Maybe they've had other partners and they've been arrested for domestic violence. But let's focus on the victim. What's going on with the victim when the police arrive on the scene?
The police have transitioned to capturing as much evidence initially right up front as possible. A lot of times they have body cam, they call it Cobain video, or they have tablets where they're actually videoing the alleged victim. And what they're doing is they're capturing evidence that might be admissible later on at trial, depending on if there's exceptions. There's rules of evidence that don't allow hearsay, out-of-court statements offered to prove the truth of the matter. That's hearsay. But there are exceptions. One of them is an excited utterance, which is a person stating something under the stress, having been affected by the stressful event, and it's near in time and proximity in space. So what you have is generally a woman, but it could be a man as well, who police are dispatched out, 911 or have a call, and they're still in that stressful event, and they're still being affected by that stressful event, and they're still excited, and the utterance they give of what happened might be admissible should a judge rule that it's admissible. Now there's case law that says that, They have to be under that stressful event. It can't be for purposes of prosecution, like a police report. They can't just be 2 days later saying, yeah, this is what happened to me. He
Sure.
did this, he did that. But what happens, the police get there, they're trying to immediately capture that evidence in order to push back on this this percentage of people that are being abused that turn around and later want the charges dropped. Be abused, turn around and want the charges dropped.
But why do you think they do that? Why do you think they drop the charges? I mean, in your experience on both sides of the aisle, why do you think they go and do that affidavit?
There is a dynamic out there that goes on in certain cases where I think there's just some ignorance out there.
Mm-hmm.
There's an absence of where they are in life. They're not taking that bird's eye view of themselves.
You're talking about the victim.
The alleged victim, yeah. I think that they don't see the big picture a lot of times. And that's on the ones where they're actually being abused. Now there are others where they have a motive, where they have a motive to seek prosecution of somebody that's not legitimate or not right. But on the ones where they're actually being abused, they, for either reasons of persuasion, threats, niceties, being financial reasons, loneliness, being left out without any support, lack of family support, ignorance of other services that are out there, victim services, the women's shelter, or that's all they really know. I mean, in life, maybe they grew up in that, and that's the unfortunate thing is that's all they know in life, and that's where they find themselves. I wouldn't say comfortable, but that's where it is that they are, and that's the only world they see. And a lot of the programs and a lot of the direction that law enforcement is taking, it seems to me, is to try to what I term a break state, get them broken out of that state where they're in, and take that bird's eye view, that 65,000-foot view as to where they are, so that they can see what's going on. And that's in the cases where the abuse is occurring and where they're trying repeatedly to have the case dropped or get out of that situation.
And just going to the alleged perpetrator side, looking at it, you mentioned that there's sometimes people have motives of nasty divorce.
Correct.
They file charges to seek an advantage or make the person lose their rights to their children, or blow it up.
Or sometimes it's mutual combat. I mean, it's human nature, unfortunately, to come to physical blows, and we're a society that protects our women and our children.
Yes, sir.
And it's sometimes we have to, as defense attorneys, fight the broad general brush that if there's an abuse situation, generally between a man or a woman, that the man's the aggressor. And sometimes that's not always the case.
Right.
And it's a delicate subject, and I'm not trying to discount or minimize the abuse that women do face, but sometimes there are situations where we deem mutual combat, and that's what it is. It's people fighting.
Well, in the last part of this, we used a very hot button example because I wanted people to know about the importance of preventing domestic violence. That if you are in a situation that you feel that you're in danger, it's not going to get any better. You've got to do stuff to help yourself, and there are programs out there. Get more information, find out, really think very carefully if you're going to drop charges that you're doing it for the right reasons.
Yes, and definitely, because we don't want to see these matters escalate to the point where something extremely tragic happens, and we see that a lot, unfortunately. There's the women's shelter. You can call the women's shelter. You can call the crime victim services there at the district attorney's office. They have a couple of ladies there that
Oh, they're wonderful.
Rosa Maria Cervantes and I think Shirley is her name. And they will, there's also domestic violence classes or matters that you can, counseling that you can reach out to.
And I want to get all three sides of this, and I wrestle with this a lot too. As an attorney, you've done it from both sides. You prosecuted people, put people in jail for doing something like this, and also have had to, it's not a chore. I mean, you know, it's our job, it's our sworn duty as attorneys to represent somebody zealously. What's your take on domestic violence as an attorney that has done it from both sides, prosecute and defend?
Well, ultimately we're trying to restore the peace and dignity of our community. I mean, we either do it representing the people of the state of Texas, or we do it representing one individual to the best of our ability according to the law and the evidence. But the ultimate goal, I believe, is to try to help people get to a point where they have some peace and stability and restore dignity to their lives.
So the accused, I mean, there are programs out there for the accused if they are found guilty they plead, that they can do different things to, instead of just slugging somebody or you know, causing property damage or, you know, treat somebody a certain way.
There's anger management classes, there's batters and prevention programs, there's anger, insight, rage programs. There's different programs out there, assuming that they are placed on community supervision or probation, as it used to be called, that are conditions that they have to follow and successfully complete.
Well, we're watching Mark Stolley, and we've covered the juvenile justice system, CPS, and often these cases go together. We've used the example of domestic violence and the adult system, and now we're going to get back to one of my favorite topics, politics, when we come back.